Okay. Sir, state your name for the record, please.
Michael Gwinnett.
Okay. This is case number 250-554-7301 and case number 250-554-7401. Pearson Michigan versus Michael Winera. Appearances, please. Mr. Vincent.
Good afternoon, Magistrate. Good to see you. Steve Vincent for the People, P71917.
And good afternoon, Your Honor. Sorry, if my computer goes out, I'm gonna have to sign in on another device. I forgot to bring my cord for it. But Brandon Bird, on
Okay.
behalf of Michael Gennari, my client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
All right. The court will enter a not guilty plea on behalf of your client on both cases. Mr. Vincent, are you seeking a cash bond in this matter?
I am 100,000 on both.
Okay.
Just a couple of things, Magistrate. You're well aware of the allegations, but I think you'd be interested in this. He has two ongoing cases, one of which is in 36th District Court. He's got a B&E without owner's permission utilities fraud. It's still ongoing. I think the B&E part of that ended up getting dismissed. He also has a case going in circuit court for the same type of allegations. He has aggravated stalking, but in addition to that, he has 2 counts of R&O as well as a B&E. He's got a jury trial scheduled for that March 31st of 25. Same complaining witness that we have here. And most recently on the Register of Actions, December 18th of 24, there was a motion filed by the prosecutor's office to increase or revoke the bond. So,
okay. I figured that after reading the investigation report with this case, given these close in time incidents, the complaining witness has a PPO against the defendant. And what I find particularly concerning was that he has a prior conviction for aggravated stalking. So, Mr. Bird, I'm open-minded. I'm waiting to hear your argument and response.
All right, first of all, let's start with the simple part. 35-year-old lifelong resident, Your Honor, 2 children, indicates to us that he can stay with his father, and will stay with his father. Self-employed, fixes our cars, and does home repair, Your Honor. He is on multiple medications for multiple issues. Right now he's in the hospital, but if we can mark his file medical, it'd be greatly appreciated. Unfortunately, he'll be unable to afford any amount of bond, Your Honor. And I don't believe 100,000 is necessary, especially on both cases. Now, here's the kicker, Your Honor. From what my client indicates to us, the complaining witness in this matter is actually his guardian, and the conservator over his money. So she actually handles his medical, and all his money goes to this person's account. Goes to this person's account. So basically, he's gonna have to find some way to at least petition the probate court to get his money and to find a new guardian. I'm not saying aggravated stalking is correct. I'm not saying it's good. I'm not even saying he did it right at this point. But for argument purposes, Your Honor, you have somebody that has control over your body, understands that you have a mental condition, and took the responsibility to be the guardian over you, took the responsibility to take care of your money as conservator of that money. If what my client indicates to me is true, you can have conservatorship over your finances, and then after I'm not sure. After you find out that it's almost like after you find out you got yourself into more than you expected, that you put a personal protection order out on somebody in which you still maintain the right to their finances, and all their finances come into your bank account. I do see a problem with that, Your Honor. I do see a problem with that. And respectfully, I would ask this court, he could stay with his father. I asked him if his father could take over his guardianship and his conservatorship. He said his father his father, he indicates to me that his father is willing to do it. Now,
Well,
I'm
let
not
me ask
sure
you this,
that,
Mr. Byrd. Let me ask you this, Mr. Byrd. His guardianship and with respect to the paperwork, is this a consensual, an agreement in terms of power of attorney, or was this court ordered? I lost Mr. Byrd. He said he would.
sorry about that, yeah.
No problem.
That's why I gave
You did warn me. You did warn me. All right, go ahead.
No, but I left off when you was asking me about guardianship.
Oh yeah, my question to you was this a voluntary situation where he knew his health issues and a power of attorney and the paperwork was done that way, or was this a court ordered guardianship?
Regardless if it's a court ordered guardianship, the person that's the guardian or conservator have to agree to being the guardian or conservator.
I understand that, Mr. Byrd, but I think there's a big difference in my mind, the distinction between the two. I understand they have to agree.
And that I can't tell you, Your Honor. I'm not about to make up an answer for it, and I'm not even that well versed on probate. I have done it a little bit in my life when it comes to guardianships, but I wouldn't want to start answering questions just on probate matters.
Okay.
But the fact about it is this person has guardianship over his body and guardianship over
yes. I get that. One last question, Mr. Byrd. How long is it anticipated your client's going to be in the hospital?
I'm not sure. If Corporal McCree has or Mr. Garaneri has better answer, could better guidance in that, it'd be appreciated.
Yeah, from my experience from coming down here very often, he should be out within about no more than 3 hours tops.
Okay. All right. Okay.
I mean,
all right.
Sorry, Your Honor, permission to speak.
Go ahead.
I do believe that he needs help. He is on multiple medications for a variety of different issues.
I know.
Which I'd rather not state. But being up under his father, and if we put a tether provision, I do think that would be the best recourse of action in this matter.
I would appreciate that, so I can get to my hospital appointments.
Okay. All right. The court haven't heard argument as to bond. Mr. Vincent was requesting $100,000 cash surety bond on both cases. And I am inclined to agree with him on this matter. I think the complaining witness is the same person in both cases. These are back-to-back instances within a matter of hours. And the fact that your client, Mr. Byrd, has been previously convicted of aggravated stalking is further evidence to me that he is a danger to the complaining witness. And so for those reasons, I'm going to adopt the recommendation of the people with $100,000 cash surety bond on both cases.
Cash surety, what does that mean?
You have to have 100,000 to post bond. If not, they're going to send you to Wayne County Jail where you were sitting to trial.
So I'm not getting.
You'd be going to Wayne County Jail.
I'm going to Wayne County Jail.
All right, and on the case ending in 5473, you'll be fitted with if you're able to post that bond with GPS to the house arrest. You cannot go back to the Pembroke address. You cannot have any contact with Catherine Webster. And you're not to possess any handguns, firearms, or other dangerous weapons.
Your Honor.
Wait.
You have any questions regarding your bond conditions and the court dates? Which I'm about to give you your court dates. I would advise you to make a statement. I would not advise you to make a statement.
And permission to
speak. Let me finish and I'll let you speak.
Sorry, I thought
Bond
you
bond redetermination be January 27th, 9 a.m. in front of Chief Judge McConaughey on both matters. Probable cause February 3rd, preliminary examination February 10th, both in front of Judge Jack K. Is there anything else either attorney wants to put on the record?
Yes, Your Honor. I'm just asking, would you even think about it? So maybe his father could bail him out and tether house arrest unless it's a medical appointment. I don't believe it's doing the system any justice to have a person with his conditions inside the confining jails and puts a stress on the jail. And I believe that a tether with house arrest, unless it's a medical appointment, it allow the courts and everything else to monitor his whereabouts. If he steps out that house, he's gonna go to jail. He's gonna go to jail. But a GPS tether with full home confinement, I think that would be the best thing for the system. It'd be the best recourse of action for the defendant with the
Mr. Byrd, I'd be inclined to agree with you if this wasn't back-to-back conduct within hours and he had not been previously convicted of aggravated stalking. And then the complaining witness, as I understand it, has a PPO against him.
It's the same witness. It's the same witness, Your Honor.
Ma'am, sir.
And she
So
also,
I feel, okay. I want to say this, and then the matter is over with. I feel that he is a danger to her, regardless of the background circumstances, being guardian or whatever. Work it out, in court or whatever needs to be done. But this alleged behavior is unacceptable, and I am concerned about the safety of the complaining witness for the reasons I just stated. And so I believe he's a danger to her. And so, those are the reasons why I'm giving a cash bond in both matters. Bond redetermination Monday, January 27th. Probable cause February 3rd. Preliminary examination February 2nd, and February 3rd is a probable cause hearing both in front of Judge Jack K. All right, that concludes this. I'm sorry.
Thank you for hearing me out, Your Honor.
Okay, that concludes this arraignment.